My boss fired me for taking cancer leave, so I used a hidden HIPAA violation to bankrupt their $50 million company. The story isn't just about revenge, it's about corporate arrogance meeting federal law. I was a loyal employee for 12 years at a mid-sized healthcare consulting firm we'll call Apex Solutions. Apex was worth over $50 million. I was their most reliable project manager, bringing in millions in revenue. My boss was an ambitious, ice-cold CEO named Evelyn. She was obsessed with appearances and had zero tolerance for anything that might slow down her ascent. My world came crashing down when I was diagnosed with a rare, aggressive form of cancer. The diagnosis was terrifying, but I had a safety net. Under federal law, the Family and Medical Leave Act, or FMLA, protects an employee's job for up to 12 weeks of unpaid leave due to serious medical conditions. I had built my career around following rules, and I expected the company to follow them too. I immediately filed for FMLA leave. I provided Apex's HR department with the required medical certification, confirming the seriousness of my condition and the necessity of my treatment schedule. I was assured by HR that my job would be protected while I focused on getting well. That assurance lasted exactly 3 weeks. Evelyn hated any sign of weakness or inefficiency in her organization. She saw my FMLA leave not as a legally protected right, but as a hole in her meticulously crafted workflow. She knew she couldn't fire me for taking FMLA leave directly. That's a clear federal violation known as FMLA interference and retaliation, which carries stiff penalties. So she started a passive-aggressive campaign designed to force me out. First, she transferred my largest, most prestigious project client to her personal protege, claiming the client needed, quote, continuous, uninterrupted support. This client was responsible for nearly 30% of my annual bonus structure. I protested via email from my hospital bed, citing the FMLA's promise of job restoration. She ignored it. Then came the calls. HR and Evelyn began calling me frequently, asking for updates on my condition, demanding to know specific dates for my chemotherapy sessions, and even requesting details about the prognosis given by my oncologist. They framed these intrusive questions as planning ahead, but the FMLA explicitly protects an employee's medical privacy during leave. I felt like I was being audited for having cancer. I was fighting for my life, and now I was fighting for my job. I began to sense the legal danger. I immediately hired an employment law attorney, Sarah, who specialized in FMLA and workplace discrimination cases. Sarah told me that Evelyn was building a paper trail to claim business necessity for my eventual termination, or worse, attempting to breach my medical privacy so they could claim I wasn't disabled enough to qualify for FMLA. Sarah advised me to cease all communication about my medical specifics and only communicate through her. This slowed Evelyn down, but only marginally. The harassment escalated. Evelyn sent the final, scathing email one morning. It wasn't sent to me alone. It was sent to me, Sarah, my lawyer, the entire HR department, and, crucially, to the client contacts who worked on my transferred project. The subject line was chilling. Urgent, Project Lead OP's health status and succession plan. The email stated in cold clinical detail that due to my aggressive stage 3 cancer diagnosis and uncertain treatment path, Apex was forced to permanently remove me from the client team and replace me with Evelyn's protege. The problem wasn't the firing, which was illegal in itself. The problem was the inclusion of the client contacts, who had absolutely no legal or business right to know my specific medical diagnosis. Evelyn, in her rage, had committed a profound error. She had illegally disclosed my confidential, protected health information, or PHI, to unauthorized third parties. She had violated a major pillar of American medical law, HIPAA. I realized Evelyn didn't just give me the drama I needed for revenge. She gave me the federal legal leverage I needed for absolute destruction. This was no longer a simple FMLA lawsuit. This was a weapon. My employment lawyer, Sarah, initially planned to file a strong case for FMLA retaliation and wrongful termination. That suit would have won me my lost wages, my bonuses, and perhaps a decent settlement for emotional distress. it would have cost Apex a few $100,000, a painful mosquito bite for a $50 million company. But when I showed Sarah the email where Evelyn explicitly detailed my aggressive stage 3 cancer diagnosis to unauthorized third-party clients, the entire strategy changed. Sarah leaned across the desk, her expression suddenly serious. She didn't see an FMLA case anymore. She saw a federal bomb. "OP," she said, "Evelyn just committed a major HIPAA violation. She disclosed protected health information, your specific diagnosis, to external entities who were not part of your treatment or the company's internal compliance team. FMLA is a lawsuit. HIPAA is a federal offense enforced by the Office for Civil Rights, OCR, and the penalties are designed to be punitive. We're no longer aiming for a settlement. We're aiming for structural damage." We immediately filed the FMLA suit in state court as a decoy. The suit was standard, making Evelyn and the company believe the fight was over lost income. This allowed us to operate the real federal action, the HIPAA investigation, in complete secrecy. The key to maximizing HIPAA penalties is to prove the violation was systemic, not isolated. If it was just Evelyn's mistake, the fine might be manageable. If the entire company culture was reckless with patient data, the fines could reach millions, threatening their liquidity. Sarah and I began building the case for systemic failure. As a former project manager deeply involved in the company's IT infrastructure, I knew exactly where Apex cut corners. I had access to internal email groups and shared cloud drives before I went on FMLA leave. I remembered warning the compliance team repeatedly that sensitive employee medical certifications and client diagnostic data were often saved in unsecured, poorly labeled SharePoint folders, a huge HIPAA no-no. We subpoenaed the company's internal communication records related to my FMLA application. This gave us a treasure trove of evidence that went far beyond Evelyn's email. We found HR threads discussing the medical diagnoses of other employees on FMLA leave. We found instances where client billing data, including sensitive procedure codes and patient names, had been carelessly shared in non-encrypted email attachments across the entire project management team. The severity of the violation escalates based on the company's knowledge and intent. HIPAA violations are classified into tiers. Tier 1. Unknowing violation. Fine $100 to $50,000 per violation. Tier 2. Reasonable cause violation. They should have known. Tier 3 and 4. Willful neglect. They knew and did nothing to fix it. Fine up to $50,000 per violation with an annual limit of $1.5 million. The emails I found, my prior warnings about unsecured SharePoint drives, and the clear documentation that Evelyn, the CEO, willfully ignored my FMLA rights proved a strong case for willful neglect, Tier 4. This wasn't a mistake. It was a known failure to implement compliance that escalated to a felony-level disclosure. Armed with this evidence, the explicit email from Evelyn, the internal HR threads, and the records showing the lack of IT security, Sarah formally filed a complaint with the Office for Civil Rights, OCR. This was the moment the federal government was officially notified that a $50 million healthcare consulting firm was operating in a state of catastrophic HIPAA noncompliance. The immediate effect was silence. The OCR doesn't announce its investigations publicly. For weeks, Apex continued to fight my minor FMLA lawsuit, confident they were managing the damage. Evelyn was smug, believing she had outmaneuvered me. But the federal machine was turning. The OCR sent a confidential notice to Apex's chief compliance officer, demanding immediate access to all data servers, HR files, and security protocols, triggering a full compliance audit. This federal order completely overshadowed my little FMLA suit. It signaled to Apex that the money they were spending fighting me in state court was irrelevant. They now had a fight for corporate survival against the U.S. government. The company went into immediate panic mode. Suddenly, the phone calls from Apex weren't about my FMLA status. They were frantic questions about who I had talked to. The mouse, my FMLA suit, had distracted them from the lion, the HIPAA investigation.
Evelyn was completely blindsided, having dismissed the mere possibility of federal intervention.
The Office for Civil Rights, or OCR, is the enforcement arm for HIPAA. They are relentless because HIPAA isn't just a fine, it's about public trust. Apex Solutions was a healthcare consulting firm. Their entire business model depended on handling patient data with the utmost security. When the OCR audit hit them, their foundation crumbled. The confidential notice demanding full access to all servers and internal compliance documents was sent to Evelyn, the CEO, and the chief compliance officer. Evelyn initially tried to dismiss it, thinking she could just pay a small fine and move on. She was dead wrong. The OCR didn't come in with a slap on the wrist. They came in with a mandate for systemic correction. The investigation revealed what Jane and I already knew. Apex was operating at a Tier 4 willful neglect level. The fact that the CEO, Evelyn, was personally involved in the illegal disclosure of my medical records and the internal documents I provided showing my previous warnings about unsecured SharePoint drives sealed their fate. They knew they had a problem, and they intentionally ignored it to save costs. The penalties began immediately. The OCR issued a preliminary civil monetary penalty that was staggering: $1.5 million for the first year alone, retroactive to the date the violation was discovered, with the potential for more fines for every subsequent year they were found non-compliant. For a $50 million company, this wasn't bankruptcy yet, but it was a massive liquidity problem. However, the financial fines were only the start. The true weapon was the Corporate Integrity Agreement, CIA. A CIA is a legal settlement imposed by the federal government, requiring the company to implement a series of intensive, time-consuming, and expensive corrective actions. Apex was now under federal surveillance. Their CIA required them to hire an independent, federally approved external monitor to oversee all data practices at Apex's expense, stop all existing projects that involved handling patient data until the new approved protocols were in place, retrain every single employee from the janitor to the CEO on comprehensive HIPAA compliance, requiring hundreds of hours of lost work time, completely restructure their IT infrastructure, encrypting all shared drives and paying millions for new secure servers. Item number 2, stopping all existing projects, was the kill shot. Apex made money by providing consulting services based on analyzing client data. With the CIA freezing their operations, their revenue stream dried up overnight. Panic struck the board of directors. Apex was a publicly funded company. Their stock plummeted as the news leaked out about the massive federal investigation. Investors who had put money into the $50 million valuation started screaming for Evelyn's head. Their liability insurance carriers, seeing the systemic fraud and willful neglect, immediately filed suit to rescind Apex's professional liability policy, claiming the company had been operating illegally. This meant Apex was suddenly exposed to potentially hundreds of millions of dollars in liability claims from their clients. Evelyn, once the ice-cold CEO, was crumbling. She was spending 18 hours a day in meetings with high-priced compliance lawyers, not to mention the ongoing and now irrelevant FMLA suit. She tried desperately to blame the HIPAA failure on the chief compliance officer, but the email trail I had provided, the one where she personally detailed my cancer diagnosis to the clients, sealed her the undisputed primary culprit. Suddenly, my small, petty FMLA case gained national attention. My lawyer, Sarah, leaked the details of Evelyn's retaliatory FMLA firing and the subsequent criminal HIPAA disclosure to a major financial news outlet that specializes in corporate crime. The narrative was perfect. Cruel CEO fires cancer patient, then commits federal fraud,
tanking a $50 million company. The public relations disaster was complete. Clients who had relied on Apex for their own HIPAA compliance were terrified. They knew if Apex was found to be negligent, their data might be compromised, exposing them to risk. One after another, the major clients, the ones who provided 70% of Apex's revenue, began invoking the moral hazard clauses in their contracts and terminating their agreements immediately. Apex was now facing $1.5 million in fines, millions in mandatory IT upgrades, a paralyzed operation, and a 70% loss of revenue. They quickly exhausted their lines of credit. Evelyn was forced to announce that the company was unable to meet its payroll and was preparing to file for Chapter 11 bankruptcy protection. The $50 million valuation vanished in a puff of federal smoke. My revenge was perfect. I was not only reinstated to my job, briefly before the company closed, and paid all my back wages, but I had used the very laws designed to protect employees to destroy the empire built on my suffering. Evelyn's arrogance didn't just cost her a few dollars, it cost her the company, her reputation, and her entire professional future.
Apex Solutions filing for Chapter 11 bankruptcy protection was the ultimate confirmation of Evelyn's catastrophic failure. Chapter 11 is designed to restructure debt and keep a company operating, but for Apex, the damage was terminal. No bank would extend new credit, no major client would return, and the OCR's Corporate Integrity Agreement, CIA, had essentially put a federal lock on their ability to generate revenue. The company quickly transitioned from Chapter 11, restructuring, to Chapter 7, liquidation, the complete and final shutdown. During the liquidation process, my lawyer, Sarah, ensured that my FMLA and wrongful termination claim was prioritized. Apex was desperate to resolve all immediate legal liabilities to facilitate the clean sale of its remaining assets, primarily intellectual property and data centers. The settlement I received was substantial. They paid me every penny of the salary and bonuses I would have earned, plus a massive settlement for emotional distress and punitive damages related to the FMLA retaliation. Crucially, my settlement included a public acknowledgement, hidden deep within the bankruptcy filings, that my firing was directly related to my legally protected medical leave. This was the moral victory I needed, clearing my name in the industry. But the most satisfying part of the liquidation was Evelyn's personal fallout. Evelyn was not only stripped of her title as CEO, but the board immediately fired her for cause, citing her gross negligence and her personal role in the HIPAA disclosure. Losing her job was only the beginning. As the architect of the company's non-compliance, she faced civil action from the company's creditors and investors, who sued her personally for breach of fiduciary duty. Her reputation, which she valued more than her own employees' lives, was utterly ruined. In the niche world of healthcare consulting, being known as the CEO who tanked a $50 million company by illegally leaking a cancer patient's records is career death. Her name became synonymous with the HIPAA scandal, as the media dubbed it. Every single professional contact who had once admired her ambition now saw her as a toxic liability. I remember watching the news report showing the last day of the Apex headquarters. Boxes were being loaded into trucks. The iconic Apex logo was being taken down. A reporter mentioned that the company's remaining assets were barely enough to cover the legal fees and the OCR fines. The company was completely wiped clean. My perspective on the situation was complicated. I got the financial justice I deserved, and the systemic failure was corrected. The federal government used Apex as a high-profile example, sending a clear message to the entire industry that HIPAA compliance is non-negotiable. Hundreds of other healthcare firms immediately ramped up their security and compliance budgets, which, in a twisted way, saved countless patient data records. However, the personal cost was immense. My battle against Evelyn coincided with my most aggressive rounds of chemotherapy. The stress exacerbated my recovery, but the fight also gave me a strange sense of purpose during the darkest period of my life. It turned me from a victim of a terrible diagnosis into a warrior fighting a corporate giant. The victory over Evelyn was ironically the strongest medicine I received.
Sarah and I later celebrated. She told me that while the FMLA violation got our foot in the door, the HIPAA violation was the nuclear option. Sarah said, "Evelyn thought she was fighting you over a salary. She didn't realize she was playing a different game with the US government, and the penalties for violating patient privacy are designed to be devastating, especially for a healthcare business." After my successful treatment concluded and the legal battle was over, I was physically and mentally drained, but I was debt-free, compensated, and had my professional integrity restored. I watched Evelyn's name fade from the industry news, replaced by bankruptcy lawyers and federal compliance monitors. The CEO who thought she could exploit a cancer patient's illness to maintain her bottom line lost everything. The FMLA was my shield, but the HIPAA violation was the sharp, precise sword that cut through a $50 million defense. If you were in my shoes, fighting a life-threatening illness while your boss illegally revealed your medical data to ruin your career, what would you have done? Would you have accepted the smaller FMLA settlement and focused only on your health? Or was my decision to use every legal weapon available to hold my former employer accountable the only acceptable form of justice? Tell me your moral verdict in the comments below.